Hey, welcome everybody to Spin Legal, your legal interest show on Wednesday, 17th of July, 2024, with your hosts, me, Peter Giblett, and her, Angela Browne. And we're both with the Invictus Legal LLP. And today we're going to be talking about default judgment. What is it and how does it apply in the courts? That sounds a very technical term, doesn't it? Default
Yes.
judgment. It's like, well, I'm going to hit you over the head. Bang. Bang.
Sometimes you'd like to hit some debtors over the head.
Well, that's what the mallet is for, right down here, you know? You know, that's where the judge hits the defendant over the head. You didn't do it right.
Yep.
Listen to my words. Okay, so as I said, welcome to Spin Legal today, and our topic is default judgment and how it can apply to you and your, maybe how it can apply to you and your legal circumstances. So, welcome.
Hello.
Okay, and let's move. Okay, so before we talk about anything, let's do our usual stint. If you need to contact Invictus Legal LLP, you can do so at 905-688-5598. You can email Angela at weareinvictus.legal or me at peter@weareinvictus.legal or visit our website at https://weareinvictus.legal. Okay? There you go. Yep. So let's get right down to it. Default judgment. It sounds a technical term, so let's discuss what it is and how it applies to cases.
Okay. A default judgment is basically an undefended action. When somebody sues you, and then for some reason you don't file a defense in the court, that person suing you could hold you into default after a certain period of time if you haven't responded.
It applies both in small claims court, in superior court, and in other tribunals as well, doesn't it?
Some tribunals, like in the Human Rights Tribunal, I recently got something where that if you don't respond to this, that will be deemed that you accept all of the allegations within the application.
Yeah. Okay, and actually that's an important aspect, because obviously with the Human Rights Tribunal, they're running quite a backlog of cases, aren't they? Right, so getting through them, that's a sensible thing, because hey, throw away the cases, put them into default judgment when they do not, when there's nothing to defend.
Yeah,
right. Make people smarten up about the way they do it. Okay, so primarily we're talking here about default judgment as it exists in small claims court, but as I say, it occurs in the superior court as well as some tribunals. There we go. Okay.
Yeah, so, okay, default judgment. You haven't defended. You do not file your defense within the 20 days, which is in the case of small claims court. I think it's 30 for superior court.
I believe it is as well. Yeah.
And then if you don't defend yourself on the 21st day, the plaintiff can go into court and ask the court to note you in the default, which means that you would not be allowed to file a defense after that date once they note you in the default. If they don't note you in the default, you can still file a defense if you can slip it in, even though it's late.
Well, in fact, actually, we kind of, that's a strict rule, 20 days. But when you think about it, if you're going to, let's say that you file a lawsuit against Walmart, however smart or dumb that lawsuit is, and we're not going to comment, but you file a lawsuit against Walmart, and of course Walmart has, you file it and you serve it on the manager of Walmart in your local store, right? Because that's where the incident that happened, right? And now you're kind of saying, well, I need my $35,000. Walmart's going to pay me; they owe me, all right? we're not going as to whether you do or not. Obviously, there's a difference between suing Walmart and me suing you.
Yeah.
Right? Because if I sue you, I serve you on the 1st of July. Basically you should be able to get the defense in by the 20th of July, because that's easily enough done. Whereas if I serve Walmart and hey, Angela, I note that you're the Walmart greeter. Are you the appropriate person to serve? And you go, I don't think so.
I don't know.
So
I
now
don't know who to serve.
So now I have to then go off and find the appropriate service person, which is likely to be the store manager or somebody at customer service. Probably somebody at customer service will take responsibility for that type of thing.
Yeah. And then they would direct it to the legal department.
Well, and again, yes, exactly. So your local Walmart store isn't going to, it's not the legal department doesn't exist at your local Walmart store. It doesn't even exist at the regional office. It exists at the national headquarters.
Yep, there's Walmart Canada, and there is a legal department there, because I have had lawsuits involving Walmart, and I've sued them there.
And of course, the issue is that now it's taken probably 10 days to get it to Walmart headquarters in Canada.
Mm-hmm.
And probably another 2 or 3 days to find itself to the legal department. And probably their first thing is going to be, okay, we've got to get this going. Let's discuss the merits of the plaintiff's claim. But they'll probably turn around, and if it's a represented plaintiff, they'll probably ring the representative and say, hey, Angela, we need a little bit more time to file our defense. I've just gotten the paperwork. And so I think if you're filing a company, don't be an ass. Don't go on day 21 and note them in default.
Mm-hmm. Yeah, because this what happened to me before as representing a corporation. I was their legal representative for all the times that they had to sue or be sued. So one gentleman decided to take upon himself and serve my client, which was a sizable corporation and acted across Ontario. So he served them for, I forget what he was suing them for, some contract or something that he had. And I didn't even get it, okay? In the department itself, he did serve the head office, and I think he served the receptionist at head office, which was probably an inappropriate way to serve. And then this person eventually passed it on to the manager, who passed it on eventually to the CFO. And then the CFO contacted me and said, we're being sued again by this gentleman. And he talked to me on the phone about the gentleman, what his suit was about, and so forth, and sent me a copy of it. But this was day 20 when I got it. And then what did the guy do the next day? He walked into the courthouse and declared them in the default and started garnishing.
Yeah.
And as soon as that happened, I had to immediately file a case to stop that, to put a stop to the thing with the default judgment and indicating that this was a corporation. And he filed this in Ottawa, which was also done wrong, because you have to really check your jurisdiction when you do file a plaintiff's claim about where you file your plaintiff's claim. So anyways, this gentleman, he goes there, and I go on to, I think it was whether it was a video conference or an audio conference, I can't remember. But we were talking to the judge, and the guy was, and I was saying I want to set aside the default judgment and stop any writs and any kind of enforcement actions and different things that were taking place. Okay, so basically what the court did is they immediately stopped the garnishments, and then they told the guy in Ottawa that, like, I know that you can file on the 21st day. This is a corporation. Don't you know this? This is not the right way to do things. At least you should communicate with people when something that happens, and then give them some extra time to file a defense.
And especially if the legal rep of said corporation, contacts you on day 20 and says, I need a little bit of time, at least give them 10 days.
Yeah, right? He was a self-rep. Yeah. Self-reps, I mean, this is one of the things with self-reps. They think they can do it. He eventually lost the case, even though he filed that. We filed the defendant's claim, and he eventually lost the case.
Yeah.
But this was a case that went on, and it was very, and there was just the way he was doing this. You don't do this type of thing, in that. So if you're suing Walmart, or if you're suing Costco, or Tim Hortons, or anybody like that, at least be respectful. Maybe call the head office, find out who to serve at the place that you're suing, and if the store has its own corporate identity, who to serve there. Be
Well,
very, very
yeah,
careful what you do. You can't be just going
yeah.
around throwing suits all over the place and then trying to enforce them, because they're probably not going to be enforced, or somebody will come back and then there'll be costs issued against you.
Well, going back to that Walmart example I used, and probably the vast majority of Walmarts that are in Canada are corporate stores, but
Yeah.
every once in a while you find actually that they are a franchise.
No, there
Right?
are a couple. There's a lot of McDonald's stores that
Yeah.
are independently owned.
And a lot of actually, yes, exactly, a lot of kind of big corporates that sometimes, like pretty well all Tim Hortons, as everybody knows, is franchise. So
Mhm.
you're not going to be suing Tim Hortons head office.
Yeah, you're not
Right?
going to be doing
You'll be
RBI
suing the
International.
franchise. So you
Yeah.
have to know the right person to sue. And part of that is about how you deal with, how you deal with service, how you can put them in default, is all about knowing that. Because if you have sued, if you sue Tim Hortons head office and they're the wrong person to sue, well, they will come back to you and, they'll probably eventually come back to you and say, no, it's not us. You need to sue the franchisee.
Yep, exactly.
Right?
And the
And
franchisee's number is 1238973 Ontario Limited. And the person who is in charge is Jack Jones.
Yeah. Well, they may or may not give you that information. What I was about to say.
Yeah. Sometimes, most of the time they will, but sometimes they
Probably. Yeah.
Occasionally they don't, but they were very, very helpful. I mean, I did sue a Costco one time. Of course, it was an employment matter.
Yeah.
And the head office was very helpful.
Okay.
And they were also the ones that helped negotiate a settlement.
Yeah. So once a party has been noted in default, once a defendant has been noted in default, the plaintiff can ask for a default judgment. Technically, you can ask for them. You can say, there's a tick on the box that says I want to put them in default, and there's another tick on another box that says can you give me default judgment?
Yeah.
Generally speaking, I think it's
judgment. You need to calculate the costs, and then you issue a cost with the default judgment certificate.
Well, I was going to say that I think it is technically bad to actually put them into default, note them in default today. If you're going to note somebody in default, do it today. Then work out the default judgment stuff tomorrow and put a separate application in for default judgment.
Yeah, particularly how you're going to enforce it.
Yeah.
And at that point, the defendant cannot defend themselves. They cannot file a defense. Okay. And yes, they could be subject to various methods of enforcement. And this is the thing. So basically, plaintiff can take the next step. They could start garnishing your bank account, garnishing your wages, seizing and selling your car, doing different things like that could be of value, where they could attach certain assets. And that's and they do that without any further notice to you.
Yeah. And okay, let's make this clear. Default judgment, so you're aware, this is the definition of default judgment, is the disposition of the case in favor of the plaintiff without a trial.
Yeah.
Right. So essentially, none of the evidence has been tested. The judge, well, it could be that the judge makes their mind up. In the case of a credit card debt, it's basically, hey, I've got evidence that show you owe me $20,000. And essentially, while there might be the defendant may have some evidence that, hey, I don't owe $20,000 to the credit card because you've forgotten that, hey, these illicit purchases were made on my card, right?
Yeah.
that
And
kind of
basically, what we have to do when you have a default judgment as a plaintiff is you have to move things toward an assessment, either an
yeah.
assessment in writing for what's called liquidated damages, like the credit card that Peter referred to,
Yeah.
or non-liquidated damages,
Well,
such as damage
yeah.
to your home or something, which is something that the judge has to hear.
Yeah, and in many cases, the judge has to hear it and has to hear what the evidence is, and the judge will be sitting there and questioning the plaintiff, much as they would have been questioned in a trial, except what will happen is that there'll often be questions that the plaintiff's representatives will make, and there will be questions that the judge will make, and the judge often places themselves in the position of the defendant.
Yep.
Right? They do that quite deliberately. It's not that they're saying, "Hey, Angela, your evidence is utter bullshit. I don't believe a word of it." Right? It's that actually, by taking that case and taking the position of what the defendant is likely to see, they test your evidence as best they can. They're protecting their judgment from the future.
Yeah, exactly. So you protect that judgment, you put it in there, and then after that, you need to take steps to enforce that judgment. And
Yeah.
you know the defendant very well, you know what properties they own, you know if they have any expensive vehicles, or you know where they bank, you know where they work, that sort of thing. Then you start to use these other methods of enforcement. And they take a number of steps. You have to be taking the steps. Everything has a number of steps to take and to go forward.
Well, there's a number of things. You can get a writ. You can get a writ of, well, for example, property. So, for example, if they own a car, if they own a $50,000 car, you get a writ of delivery for that
So the
car.
writ of seizure and sale. Writ of seizure and sale.
You can also, yeah, I was going to say,
writ of delivery is something else. Like if they took your car and it's sitting there, and then you're trying to get the car back. That's what a writ of delivery is.
Oh, sorry. Yeah. Okay.
Yeah, that's
so you can do a writ of seizure and sale.
Which, you have through small claims.
Yeah. Sorry. Thank you for correcting me.
Yeah.
The writ of seizure and sale can apply to both property and can apply to real property, i.e., real estate, and personal property like a car.
Yep. Yep. And a garnishment is usually funds, taking it from people who owe you money, whether it's an employer, someone who's a client who owes you a ton of money because you just refinished their basement. They could be tenants. There's a lot of people you can garnish from.
Well, actually, that's an interesting one you said about tenants. I was on the phone to a court today talking about a default judgment because I'm having to put paperwork in, which I'm transferring from a tribunal. And in putting the paperwork in, she was the lady at the court clerk was talking about a number of things, and I said, yeah, we're looking at enforcement. A debtor examination, not a garnishment. But at this stage, if we were to do a garnishment, we'd probably garnish against the new tenant's rent. And she said, "Oh, you can't do that." I said, "Yes, you can."
Yeah,
she didn't know that.
Like Joe Cole paid me $1,500 a month rent each month on the 1st. So what I do is I garnish Joe Blow, but you have to know who their tenants are and where they are.
Oh yeah, of course.
Have to serve them.
Well, yeah, but for example, if you got judgment that has just been made against the landlord in favor of the tenant, say the LTB and does a miracle and actually orders the landlord to pay the tenant $15,000, and the landlord refuses to do so, the tenant goes through the enforcement procedure. It's possible for them to garnish the the next tenant in that, the income from the next tenant, because they know where they are, because hey, they left that rental unit.
And then a way to do that, if you don't know what they have, Many times people don't know what the defendant owns or where they work or where they bank. You do a judgment debtor examination.
Yeah.
You can ask these questions, and they have to answer them, and they have to provide evidence of these things, like maybe pay stubs from their employer, bank statements, or different things that they have, or if they own property. You may want to ask them if they have any tenanted property,
Yep.
or is the property just owned by them and occupied by family. So there's a number of things that you could ask. And then you look at it. Does the property have mortgage? Does the property have any other security interest against it? If not, you're first in line. Just pop some money on there, and if they want to sell the property, they got to pay you off first. And this could fester. And this could fester.
Okay, moving on. So what happens if the defendant doesn't pay a judgment in Ontario?
It festers. The court judgment doesn't go away. And the plaintiff can go out and enforce it until they get paid.
Well, okay, so then, of course, interest is added.
Absolutely. There's interest added, and the interest is added at the beginning, because when judgment is made and when post-judgment is made, when you do your post-judgment executions, then they add that. Pre-judgment is before, like between the time of your event that happened and the time that you receive judgment.
Yeah.
So
and this pre-judgment interest is only applicable, by the way, to small claims court and probably superior court as well. But it happens from the date of the event to the date of the judgment. For example, you will not get a pre-judgment interest being paid by somebody like the Landlord and Tenant Board.
Yeah, they tend to have a post-judgment interest only, and it starts to collect.
They will basically say on the 24th of June 2024, judgment for whoever in the amount of whatever, with interest. If this payment isn't made by the 1st of July, it will collect interest at X% per year. So they tend to do only post-judgment interest at some of the tribunals. So that's the second part. And in small claims court, currently, post-judgment interest is currently tagged at 7%. It's interesting. There's a big gap, the 5.3 for pre-judgment and 7% for post-judgment.
Yeah, and what they do is the Bank of Canada, it's a quarterly interest. Like you go through the chart on small claims.
Yeah.
When did the event happen? You do it. And this would be your pre-judgment. And then at the time of judgment, then there's a post-judgment for all of your execution. So there's a whole range of calculations you got to do when you do what they call an affidavit for enforcement purposes. And so this is one of the things. So now, because the Bank of Canada rates have gone crazy, our pre and post judgment rates have gone up. It'll probably go back down again as the interest rates gradually go down.
Well, I was going to say that right at the moment, of course, there's probably is affected by the bank rate, but of course at the moment the bank rate is currently going down. So it's possible the fourth quarter of 2024, the post-judgment interest rate may actually go from 7% to, I don't know, let's say 5.5% or something.
Yep, and it's done. They have a formula for doing it. I don't know how to figure that one out, but they do.
Yeah, right? No, I agree. And it would probably take you more time to figure out that formula than you have to worry about it.
Yeah. And the other thing too is that there's costs also. Every time you enforce a judgment or try to make a move to enforce a judgment, there's costs involved. And there's also costs when you go to an assessment. You can get an assessment where even legal costs can be considered.
Well, I was just going to say, well, it's an interesting question. How much does this impact the debt owed? A couple of months back, I did an enforcement for a debt that was the original debt was just under $7,000. Now with interest that has been paid over the two or 3 years, and with subsequent court visits and wasted time and etc., now the debt owed was $12,500.
Mm-hmm.
Right.
Yeah.
So that quickly mounts up by the debtor not actually attending court, not actually responding to any of those things. And for example, if you're the one I was calculating today, $6,500, it's a $1.20 a day, just under.
Yeah.
Right.
And it just keeps going and keeps going until
it keeps going.
Yeah.
Yeah.
Okay. And then there's also, if it's a landlord-tenant matter, if this person stays at the place longer than the day that they're technically evicted, each day has a daily compensation cost.
Yeah. Yeah.
So these things, people have to, who are in a position where they have an order against them, they need to be very, very careful about it. Try to defend it as soon as you can. And even if you can't make a full defense, at least put something on paper where you feel that you may have a case, so that you can at least sit down with the other party and try to work it out. And as for, and the other thing too, how does this impact? I mean, a person can, sometimes what happens, a default case does can get set aside. Okay. The courts are getting a little tighter on that, but there has to be good reasons to set it aside. And many times the person didn't receive service. Right? Maybe there could be some issues around, there's a lot of different issues, service issues, the case itself, whether they named you properly or they should have, there's a number of things, or the person feels that there was a defense, it was a meaningful defense. So basically, a debtor who has been unfortunately caught into this default judgment cycle can go back and say, okay, I want to file a set-aside motion. Okay? Yeah. So you're going to ask the court to put this aside. So when once they file that, immediately there's no more enforcement in the court. The court stops any further enforcement until the matter is heard. So then they set a date at some point down the road when you can argue to the judge about why the matter should be set aside. You have to prove that you're acting in a relatively quick manner. Okay? Like, you don't go in there and have this set aside like 6 years after the judgment has been issued. Okay? Because they want you to act fairly quickly. Secondly, you have to argue that there's a meritorious defense. Okay? And that's not just saying, oh, I have a defense too. I have a point of view too. No, there has to be a meritorious defense, okay, to show. Like, if you can show that you paid that credit card bill and that you made payments, but they didn't acknowledge them, that could be part of your defense.
You got a chip from the bank that you went to in Hamilton, and you've got the next month's credit card bill that showed that they never took that chip into account.
And you also have to have a good reason why you didn't defend yourself within the 20 days limit.
Yeah.
Like, were you away on holidays? Were you?
For example, one good reason I guess could be that you were unconscious in hospital for the last 5 years.
Exactly. Okay. There could be lots of reasons why people don't respond, or maybe they didn't serve it properly on you. Yeah. Maybe you live at 671 Queen Street instead of 761 Queen Street, where they did serve it. So there's a lot of things that do happen. Okay, so there's ways to do that, and then you start figuring out when. Many times the debtor finds out when enforcement proceedings start. Okay, so they have to go to court to do that, and it may still cost you to get that default judgment set aside. So you have to look at costs too about this. Okay, many times at a default hearing, sometimes you can just settle it with the people. Okay, and he says, yeah, I agree, I owe $7,000 about that with the creditor, but I don't think I owe $15,000. They're crazy. So you're going to make
Well,
some
actually, one of the things that you have to be careful of, for that example, $7,000, you owe Mastercard $7,000, on the 1st of July, 2019, you stopped paying. Right? Of course, what happens there is they accumulate that debt at probably in the region of 23% per year. You'd have to look with your credit card terms and conditions, but that's probably what they'll do. So essentially, that is a debt that's mounting and mounting and mounting, continuing forever. So that debt, doesn't go away, and actually when you go into court, which might be a year or so later, you may actually be owing, like, you've gone up from 10,000 to 13,000, let's say. Right? And of course, companies like that will add legal fees on top of that before they even take you to court. So they've got legal procedures that they do, and they don't even take you to court without adding, let's say, another $1,000 of legal fees on the top. And so, hey, your $10,000 you owe is now sort of like 16,000.
And these things and these things are legal to do as long as there was a contract between you and the company.
Yeah.
For example, if you're paying for a new car, and there's and you're paying over on a line of credit, you take a line of credit from the bank, and the line of credit is charging you 8% a year. So this might be above the court rate. It's the 8% a year that becomes your pre and post.
And that's a key thing, actually, for things like credit cards. When you're talking, some of these credit cards could be 28%. They're you look at the paperwork, you look at the terms and conditions, that credit card 28%. And if you've got you topped your credit card out at $10,000 and you found out you couldn't afford to pay it anymore because you were unemployed, hey, all of a sudden now your $10,000 debt suddenly mounts.
Yeah. So this is one of the things that that could happen, and that's why what you thought was your $7,000 credit card debt turns into a $15,000 credit card debt when it goes to court.
Yeah. And it's already had all of the legal fees, etc., added. Okay, so how can this impact the debt owed? Let's talk about also next, what are the options? So you've not been to court. Actually, for the person who's collecting the debt, what are the options?
Well, as I stated earlier, there's enforcement options. You can seize a valuable, like a real property or personal property from the person, garnish a bank account, their employee, or if they're a contractor, anybody that might owe them money, go for a judgment debtor examination to learn what they might owe and what kinds of resources they have. They have to answer these questions, because I think even you've been through this, and I've been through this, where we had to put a judgment debtor into jail because they did not show up for a judgment debtor examination.
That's kind of something odd. They don't tell you that, hey, you can send somebody to jail in paralegal school.
Yeah. And that puts more enforcement authority onto the plaintiff. And they also have to answer questions. They can't just show up and go, no. They have to answer the questions. They have to participate in the discussion.
Yeah. And of course, then let's get on to what the options are for the defendant, or for the person who's been found in default, has a judgment against them. Those options, for the debtor, realistically is, damn well show up, answer the questions, right? What do you earn? Nothing.
Yeah, right? I'm broke. I'm living on the streets.
Yeah, I'm living on. Well, actually, it's like I was on AI, and that just finished last month. Now I'm contemplating what my options are. I've tried for jobs for months on end. It's quite possible I'm going to be evicted in 3 months.
Yeah, there's a lot of that kind of thing, especially
Yeah.
happening today.
Yeah.
So I mean, but the thing is, you have to go in. You do have to tell the truth. You're put under oath, and you can't lie at a judgment debtor examination either. You can't hide assets because if you're found to be hiding assets, that can also be coming back to bite you. So
Hmm.
there's a lot of different things that would do. My kind of thing is if I'm representing a judgment debtor that has gone to that stage, is I try to work out the debt and try to work out a payment plan that's comfortable for the
Well,
person.
and that's exactly the the problem that I had is that I had an agreed payment plan which we could have quite easily done, but the ones that I've gone through the court system with is that they didn't even show. They haven't even responded. They've been served, on the 1st of March they were served, and they didn't show up on the 5th of May. And hey, um, now now we can just put you in jail for a period of time. Now that usually gets their attention.
To be examined, they have to purge their contempt.
Yeah.
There's a number of steps that have to be taken, and I've been through all of these hearings with people, and it's a difficult situation, to be at the other end of of, uh, of one of those default hearings.
Yeah. Well, what happened, so then the question is, okay, so what happens if that defendant's actually in Australia or something like that?
That's why sometimes you have to find them and see if you could find them and if anything could be enforced in their jurisdiction.
Well, the court actually is important. The court will not take actually any of these enforcement actions unless the actual paperwork has been served in person,
Yeah, and this
right?
is one of the things that I have to let people know. People sometimes think who's never been involved with courts or lawsuits or anything, they think that somehow after they win a case, the court will go get the money for them. Right?
No.
The court doesn't physically get the money for you. Like, I don't know if they
Well,
hired their own mafiosa squad or something. Right?
well, you can certainly you could certainly think about hiring Al Capone or somebody of his ilk,
Yeah,
but
but
I think that would be a bit that wouldn't be the right tone, would it?
that wouldn't be what I would recommend.
Yeah,
You need to do legal options
yeah.
because you don't want to be ending up in jail yourself.
Right.
So,
Well,
so basically, but hiring a legal firm to help you is the best approach if you are confused by all the array of options to go after, and also if there is any collectibles.
yeah, and the point being is that if you are actually, if you think that they do actually have goods or things that you can go after, then the debtor exam is the right approach.
Yeah, and this is where you kind of try to logically know, and then if you're trying to sue people, we generally try to have a discussion with you first, just to make sure that we're not suing a deadbeat.
What you mean somebody who's on a benefit on some form of
Welfare
benefit?
or something that does
Yeah,
not have garnishability to it, and who probably doesn't own anything, could probably be rent, and they don't have a car or any valuables. Right?
well,
You
well,
want to make sure that the person you're suing has something that to go after to sue.
yeah,
But many times when we sue, we usually sue companies or employers
yeah.
or contractors, or occasionally we will sue an individual in some cases, but we also try to assess whether that individual has anything that could be turned over if there was a lawsuit. That
Well,
was
exactly, and I suppose that car, if you're settling a $10,000 lawsuit, and they've got a $40,000 car, well, you can seize the car.
yeah, you can seize the car, sell it, puts it into the sheriff, whoever does the sheriff, and then if there's any money left over, comes back to the debtor,
Yeah,
and
well,
then
it
you go
means
buy a
it
cheaper
means
car.
it means they're without a car. But hey, well, you were telling a story one time about they seized the car, and of course the guy they seized the car like at 6 o'clock in the morning, and at 7 o'clock in the morning he's on the phone to you. What the heck did you do?
Yeah,
Stealing,
it
taking
was
my car?
all morning. The guy couldn't call me tell me enough. Like there are many swear words, some of which I never heard before. And I said, okay, calm down. You have the phone this far away. I said, calm down, calm down. What is it? What's wrong? What happened? Hey, so the guy tells me that his car was gone. Hey, and I said, do you have any paperwork? And he said he did. And I said, can you read the paperwork? And he did. And I said, that's how much you owe. I said, because there have been many attempts to contact you, many attempts to collect, but my client had no other option but to do this. So after a while, this guy ran to the bank somehow magically produced the amount of money that he had to pay, and he came over to my office like
slapped it on the desk,
yep,
right?
and he gave it to me in a certified check. But
it's
what
magic.
happens sometimes.
It's magic how that money comes up. And of course, at the point when you've seized a car, let's say the debt at the time when you seized the car was $15,000. Now that kind of debt has gone up to like $17,000, $18,000 because now he has to pay not just he has to pay to release the car, doesn't he?
Yep. And I'd say once I got that, there's impound fees that are daily, and then I had it released after he paid me.
Yeah.
And that was fine. Then he just went on his way. Right? But this is the kind of thing that happens to people, and getting into trouble that way.
Yeah, pay attention or they will take your car. In some jurisdictions, things like cars are actually are not takeable.
Depending, like if it's below a certain value, it might not be.
So if you're driving around in a beat up 2002 a Dodge, then it's probably a hunk of junk and they're not going to touch it.
Yeah, they're not going to touch it. You'll look at that and said, yep, I'll probably get 50 cents from that.
But if you're driving around in a brand spanking, if you're driving around a brand spanking new Mercedes S series, then they're likely to go for it.
Yeah, exactly. So that's the type of thing where you're looking at. It's very similar to bankruptcy law, where you have something called an execution act. Certain things are not seizable. I can't go into their house and seize their furniture or their pots and pans or things that are absolutely essential. There's certain amount of things you can't seize, and if you're on a pension income or a disability, you can't seize that income. There's many other things that are not seizable. Okay? So those things are covered under what's called the Executions Act. So this is why when you're going out to enforce anything that's above that and not in the Executions Act as non-seizable, it's game on.
Okay. Yep. So that nice $1,000 dress, we'll have that kind of thing.
Yeah. Jewelry could be seized. Like like if you got a lot of gold and silver in there and that sort of thing, or a bunch of diamond rings. They wouldn't take a wedding ring, but if there was other diamonds and diamond brooches or something.
Well, okay. So you said there wouldn't. Anyway, I won't go there. I won't go there about the wedding ring.
Yeah,
I was going to say because because a wedding ring could be could have a whole range of value to it. And typically most wedding rings are likely to be kind of, let's say $1,000 to $10,000 at the time they were purchased, right?
Yeah.
If you got married more than 20 years ago, maybe that's less than $500 at the time you purchased it. Whereas, if you're rich, maybe you've spent $100,000 on a wedding ring.
Yeah, like these things, like these super expensive things, going after rich people, but rich people also have nice ways of hiding assets. And so this is what you have to be careful about, because they put them under numbered companies all over the place that own under other numbered companies.
So you have to get 15 levels deep into numbered companies owned by numbered companies owned by numbered companies owned by XYZ Corporation.
Yeah.
In order to find it. Yeah.
Yep. Exactly.
But the thing is that that depends upon the detective work and that you've got and what resources I guess the plaintiff has to collect. And again, if that plaintiff is a corporation collecting we've talked about the defendant being a corporation, but if the plaintiff is a corporation, it's more likely they're going to be gung-ho for going after it, because in fact, actually, at that point, they've probably already spent out the amount of money on the claim to get judgment for the claim amount. So now they're going just for the sake of getting of fulfilling the judgment, really.
Yeah, exactly. I mean, this is just how we
beware of plaintiffs with big, deep pockets.
Yep, exactly.
All right.
Yeah, credit card companies, banks.
Yeah.
People like that, lenders, that type of thing.
I figured out with one of these credit card companies that they actually had probably spent the debt on the credit card company on the lawyer's fees, on just looking at the hours that he'd spent at a guesstimate of what his rate would be. They'd probably already spent that lawyer fees.
Generally, these kinds of companies have a law firm that has a retainer agreement.
Yeah. Oh, yeah.
Then a paralegal or a lawyer, depending on the amount of money.
Exactly.
They would be involved in going after the money that's owed. All
right. Okay, and I think we've come to the end of our topic for today. All right, and if you need to contact Invictus Legal LLP, you can do so at 905-688-5598, or email Angela at angela@weareinvictus.legal, or me at peter@weareinvictus.legal, or visit our website with a multitude of articles that are out there about a lot of this type of stuff at https://weareinvictus.legal. There you go. And I am going to put up the favorite one for the end of the day that Angela loves to go on to.
Yeah.
So, Angela.
So what you heard today on Spin Legal or at any of our earlier shows is not legal advice. If you need legal advice that's specific to your situation, then please contact a paralegal or a lawyer. I certainly would like you to contact us, but if you want to call, you can call anybody but as long as they're a paralegal or a lawyer licensed to practice in Ontario.
Yep. And obviously, if you're listening to this and you're outside of Ontario, then you have to find somebody in your local jurisdiction, but many of the rules may still apply there.
Yep.
Right.
Yep, there are very many different provinces because the provinces are responsible for licensing legal professionals.
Yep. All right. And I kind of guess that we can leave it at that point and wish everybody a great day. And, we'll be back next week, 6:30-ish.
Same time, same channel.